It's a hearty welcome to another edition of the program Familiarized with the Law, coming to you on Star Television Channel 21, where we broadcast from our Media One Center 3 Mama Street, Book Friends, Freetown. Familiarized with the Law is a program that highlights critical issues that borders around the legal aspect. My name is Abdul Rahman Kamara, and my guest in the studio is Director Namati Lawyer Son Kita Conte. Welcome to the program.
Thank you for having me.
In today's edition of the program, we shall take our time off to look at land regime in the constitutional review process. You will all agree with me that the governance of tenure of land is a crucial element in determining if and how people, communities, and others are able to acquire rights. The aspect of land over time has posed so many challenges, especially in the method of acquisition, right to claimants, and other aspects that surrounds land regime in the states. This primarily is very crucial, but we'll come to better understand why is it important to include the issue of land in the proposed revised constitution.
Thank you again, and I think this particular topic is of singular importance to every Sierra Leonean, because in the first place, without land, we cannot call ourselves a country, because possession of land is one of the first characteristics of becoming a state. And we know the kind of things we get from land. We build our houses on land, we get agriculture from land, we get natural resources from land, which we would use to develop our country. And so it is important that we, in looking at the revised constitution, we place premium on this very significant resource that we have as a country. And I think it's a laudable step by the CRC, the Constitutional Review Committee, to devote an entire chapter on land and natural resources. And I'm very pleased to be here today to talk about that and what it means for the country, and also to highlight some of the areas that we think could be better improved to ensure that once we have a revised constitution, the issue of land will be dealt with in a proper way.
So one may be wondering, how does the current draft report deals with issues, especially on duality of the tenure in the country? In other words, you have a separate characteristics that deals with land when it comes to the western area in terms of acquisition, and also differently from upcountry in its method of acquisition. Now, in the draft, we come to the understanding that those aspects now seem to be harmonized.
Well, firstly, I would say that one of the key things the draft has done, the draft report of the committee has done, is to recognize that land belongs to the people. And so it is proposing that there be a clause in the revised constitution that says land and all natural resources, we suppose, belong to the people. And the government would be able to exploit those resources for the benefit and on behalf of the people. However, unfortunately, when we look at how the report has approached the issue of the duality of tenure, essentially the way we hold land in the country, the current draft has not devoted any significant amount of space to that issue. Now, according to some of the things we've read from the draft, the committee seems to suggest that the issue of tenure system is a divisive one, it is a difficult one, and so they do not seem to have any particular position on that. Now, I think, and a number of people think, that that is not the situation, that it is not divisive and it is not a particularly difficult issue. Because in the first place, we are aware that we have two regimes on land in the country. In the provinces, we have customary tenure systems that govern how land is acquired, how land is used, and how land is passed on from generation to generation. In the city, we also have a different system of tenure, which is based on the English system. Now, it is very clear that we are going to continue to live with these two systems. We cannot relegate one in favor of the other. That would be really catastrophic, legally speaking. And so it is important that we recognize that in the draft and grapple with that. And I don't think it's a very big job, quite frankly, because sometime in November last year, the government adopted a national land policy. And it is something we have discussed on this program on one or two occasions.
Of course.
And clearly what the policy says is that it recognizes the duality of the tenure system in the country, which is, on one hand, we have customary rules applying to land in the provinces and English type rules applying to land in the western area. But what the policy does is to push for reforms of these two systems to ensure that they are better harmonized so that people who deal across both systems do not face particular challenges. And so one way that the policy is going to deal with this is by ensuring that at the very least there is a system of registration of all lands, whether they are governed by customary rules or by English rules. So with respect to that part of the draft report from the review committee, I am of the opinion that there doesn't seem to be much divisiveness about that. The land policy, which for now is the most authoritative government statement on land in the country, has clarified that position, and so we would want to see that position reflected in the draft constitution or in the draft report that the CRC has sent out for review. Okay.
Again, given that today is the 8th of March, is the International Women's Day, I will want to take this opportunity to just say on behalf of management and staff of Media One Center that we are standing shoulder to shoulder in the struggle, challenges of women going through in the States. And this program today is exclusively dedicated to the women in this country. Having said that, it brings me to the question, especially when you look at how much has men monopolized the aspect of land right in the States. Does the current draft propose any improvement in women access to and control over land?
Well, first
I believe you must have gone through all those sections in the draft constitution.
Yes, in the draft report.
Yeah.
I think first I want to join you to commend the women of this land and the women all over the world. And we hope that countries and governments move towards ensuring that there is both equality and equity in issues concerning women. Now, it is it is good that the CRC has let this draft report out for people to look at and review and make comments. Because my reading of the current draft is that there seems to be a bit of tension between some of the provisions regarding land and what the CRC has proposed with respect to other provisions regarding basic human rights. For example, the right not to be discriminated against. Now, on the issue of land and with respect to the chapter on land that the CRC proposes, there is a very important clause that they wish to include in the proposed constitution, which is essentially that every citizen, no matter the status of the citizen, is entitled to own, to inherit, to receive, to deal with land across the country without discrimination on the basis of their sex, on the basis of their status whatsoever. So very clearly that provision stipulates that men like women should be equally entitled to all the benefits of that provision. And so, on one hand, it is a step in the right direction. Although many people and many groups, women's groups, would be disappointed at the lack of specific mention of women's rights in the draft. But I think such a clause, which really equalizes the playing field, would protect both men and women and ensure that there is some form of equality. However, I was slightly disappointed when I looked at the chapter on human rights and realized that somehow the committee has retained some of the provisions in the current constitution which many women's groups have decried and criticized significantly. And those provisions essentially allow discrimination on the basis of custom. And we've seen in many instances that these provisions have been used against women, either with respect to their ability to go for offices that are traditional in nature, such as paramount chieftaincy, or to own land in their communities. I don't know the reasoning for that. I don't know why the committee did not look at that issue very critically and take on board the concerns of women's groups and people like us who have said that in both their expression and in their consequence, they are discriminatory against women and they should not have a place in the proposed constitution. Somehow the committee is saying that that particular provision needs to be looked at again and they need further public consultation, but I doubt that whether there should be any more public consultation on that particular provision or those sets of provision, because we think that they, in the main, would seek to perpetuate the discriminatory practices that is inherent in some customary rules against women. So it's a disappointment that it is there, and I hope people who have gone through the report would get back to the committee to tell them that that particular provision has no place in the proposed constitution.
Now, Kita, quickly, I see a situation where you have colleagues that are representative in that committee, lawyers, I mean, in this case. We are expecting that they should have advised adequately as to what the characteristics and the consequences are should there be a retention of those stipulated clauses in the 1991 Constitution not to be modified in the drafts. That in itself could give a clear sense. I don't want to use, I must be careful here not to use the word better representation, but on the basis that they should have advised adequately that 1, A, B, and C, this are the resultant effects if this clause is not amended.
Well, quite frankly, the purpose of having an 80-plus membership of a committee is essentially to ensure that all shades of opinions are represented.
Of course. And
I'm quite sure that women's groups and people from different walks of life all had a hand in what we see now as the draft report. And I don't know, I'm not part of the committee, I have not been a part of any of the processes, although we have submitted and written quite a bit on some of those processes and the substance that we would love to see in the Constitution. But I don't know how that escaped the attention of those committee members, or whether, in fact, it was deliberate that it was retained. We would love to hear some feedback from them about that. But quite frankly, whatever construction is put on those clauses, they would perpetuate discrimination against women, because essentially what they would be doing is elevating customs and traditions above the Constitution. And we know that the Constitution has to be the supreme law of the land. The Constitution embodies the hopes and aspirations of the people of this country. And it should not condone, in whatever measure, the use of customs and traditions to obviate the provisions of the Constitution. The Constitution should apply across, and it should be superior to any other law or any other rule of practice that we have in the country.
Okay. Again, we are faced with a situation where the activities of multinational corporations, their involvement in acquiring land in the states, has over time provoked so many hue and cry as to the nature of the characteristics of shared contracts that they enter with the local natives, say wherever they find themselves, whether for the purpose of land cultivation, agricultural activity, or for whatever purpose, it may be mining activity. Given the high rate of environmental degradation, in this case, failure to reclaim the land as part of their activities, it's currently being experienced in the country. Does the draft adequately deals with issues of environmental protection?
Well, I must say, quite frankly, that yes, indeed, and perhaps that is due to robust representations by environmental groups and institutions that are responsible for the environment. Because within the chapter that deals with land and natural resources, there is a whole section there, perhaps a number of sections that also deal with the environment. So essentially, we see provisions that guarantee every individual within the country the right to live in a clean and safe and healthy environment, the right to breathe air that has not been polluted, the right to have access to nature. Clearly, what this shows is that we have taken on board the concerns and the current precarious situation in the country with respect to the greens that are available in the country. If you look at the hillsides, you would notice that over time we've seen a depletion of of our environment. The trees have been cut down. You go to rural areas where there is heavy mining or industrial agricultural activities, you see things being destroyed, rivers being destroyed, forests being cut down in favor of plantations. All of these things are dire in their consequences for our nation. But quite frankly, I've been impressed with what I have seen in the current draft. And I must thank those who made those contributions to the CRC. So I would say that the provisions on the environment, on protecting the environment, are quite robust. And I was quite pleased to note that, apart from the fact that the draft calls for some sort of reclamation plan from now on, or from when the Constitution comes into effect, from companies, there is also the creation of a fund that every company that comes in is going to be required to put some money up front towards reclaiming land, towards ensuring that whatever damage they do to the environment is dealt with. Because we've seen situations where currently companies come in, acquire licenses, go into communities, dig up vast areas. Once they get what they want, they leave the country. And they leave the people in a very worse state with huge pits the size of football fields. And you find it very difficult to get them to come back and reclaim the land. But I think this particular provision, which requires companies to put funding up front for any potential damage that they might cause to the environment, is an absolutely welcome improvement.
So, Nkisa, one key challenge that I think is yet to be fully addressed with respect to what you've just highlighted, when you look at the activities of the multinational corporation, is the clear-cut distinction as to whose responsibility is it to ensuring that when it comes to delineating the rights of land acquisition and other aspects that has to be followed stipulatedly, it falls within, one, the responsibility of the EPA, Environmental Protection Agency. It could be the right of, or a claim right of the Ministry of Lands, Environment, and how you name it. It could also mean that the Ministry of Agriculture, Forestry and Food Security has a stake. As of recent, the National Protected Area Authority, where you have Fauna as the enforcement director and all of these things. So the tendencies seem to be quite encompassing. You don't seem to know who has the right to ensure that these people follow the stipulated laws. For instance, if you go in the suburbs at Kamakwie, you have a company like AMR Gold, an exploration company operating there. They've dug the place all over. You don't know who has the responsibility to making the reclaim. And this, at one point in time, is suggesting the fact that it provoked the will of the EPA to come to intercede on behalf of the local natives and say the right thing must be done. That is respecting those laws of reclamation. That again is quite challenging. And the body now that is set to actually ensure that the regulatory mechanism of mining companies are followed to the letter, that is the National Mineral Agency. They too are claiming. So the whole thing seems to be confusing. I want to see in a situation where all of this thing must be morphed together to ensure you have an entity that will be solely responsible to ensuring transparency and accountability and a dispensation of all of those activities.
Well, I see that you have gone through the report as well, because quite frankly, one of the proposals in the draft report is for the creation of a super entity which would be responsible for the management of natural resources in the country. Now, honestly, I don't think that is going to resolve the situation. Because we've seen...
By having a single entity.
Exactly. We've seen in many countries the creation of super ministries or super commissions that have just grown seriously huge and confusing in themselves. And so I don't think that is the way to go. I would love to see the argument for the creation of a super ministry or a super commission to deal with these things. However, I should point out that you're right in terms of the lack of collaboration and cooperation that exists among these entities. And I'm stunned, quite frankly, that those who are in charge of these various institutions seem to be refusing to look at the acts that set them up, or the parent document that sets out what their functions are, because there shouldn't be any difficulty at all. Two things I'll say. One, these institutions, the Ministry of Lands, Country Planning and the Environment Protection Agencies, all of these have various competencies. So EPA, for instance, has mostly operational responsibilities, ensuring that companies that want to undertake large-scale mining or whatever nature, yes, they obtain licenses from the agency, and the agency monitors their activities. Now, the Ministry of Lands now purely has policy and oversight functions. So they basically would look at what is happening, and they make more laws or regulations to deal with gaps that exist in the operations of these companies. And so there shouldn't be a difficulty there at all if all of these institutions understand their remits. The same thing for NMA and the Ministry of Mines. Ministry of Mines has purely an oversight function and a policy making function. And operational activity should rest with NMA. Now, between NMA and EPA, we think, and with many other institutions, we think there has to be systems of coordination and collaboration to ensure that when people are taking steps in a particular direction, other institutions are informed and they are party to it. You don't want a situation where NMA does
effective collaboration.
Absolutely, absolutely. So, I mean, that is not going to be cured by having a super ministry or a super commission. Because we've seen, even within certain commissions and certain ministries, people not working together at all in the interest of the ministry or the commission.
Yes.
So having a super body is not the answer. What is the answer is for us to have a deliberate policy of collaboration and coordination. And you know, one of the things I'd like to point out here is that with respect to the voluntary guidelines and the governance of tenure, which is a document that Sierra Leone has adopted, we've seen how the different players have managed to bring collaboration across various ministries. So you have the Ministry of Justice sitting together with the Ministry of Agriculture and the Ministry of Lands and the Ministry of Fisheries on a periodic basis to exchange ideas and notes about how they are implementing these guidelines in their respective ministries. So these are the kinds of things that you want to see across the country. Now, these agencies have very specific functions, and I think it's for good reason, because you don't want to lump a single entity with all kinds of functions, policy oversight, operations, and regulation. It would make it a bit clumsy. And so having these entities doing different things helps specialization, and it helps focuses their attention on what they need to do. But what we need to work on is a deliberate policy of coordination and collaboration across the whole spectrum. So any institution, any ministry or agency that is doing something that borders on another ministry's portfolio, there needs to be a mechanism to bring them together periodically at both professional level as well as policy level to ensure that they are sharing notes and going in the right direction and in the same direction, because otherwise it becomes a bit untidy if there is a pull. Because we're talking at the end of the day about a single government. This is the government of Sierra Leone exercising its abilities through different institutions. So we shouldn't see the case of NMA going one way and EPA the other way, or the Ministry of Lands going one way and the Ministry of Agriculture going the other way. It shouldn't happen. Like it's really upsetting, and it's clumsy management. But it's something that could be addressed.
That process, I don't know whether is the way you lawyers often refer to it as duplicitous in terms of activities and other things. Lawyer Sunkita, looking at the definition of what constitutes natural resources and trusteeship in the drafts, what in your view do you think would possibly be the areas that ought to be improved in the land and natural resources chapter?
Well, that's a very important question, because I spoke about the issue of land, and the draft stipulates that land belongs to the people of this country, which is a very important admission, that land belongs to every one of us. When it comes to the issue of natural resources, because the definition of land legally also encompasses all of those, because land extends beneath and above the surface. And so anything underneath the ground is also part of the land. Anything above the land is also part of the land. The draft talks about the resources belonging to the state, which I think it could also reference the people. But then it suggests two things. First, it suggests that
Sorry, when you talk of resources, are you simply referring to as the goodies underneath the ground?
Yeah, basically, the goodies beneath the gold, the diamond, the bauxite, the rutile, plus whatever is underneath the sea and in our rivers and all of those things, they constitute the natural resources. Now, the draft makes two provisions here, alternative provisions. In one, it acknowledges that, yes, these natural resources belong to the people. But then it says that it should vest in the president, who would then use it on behalf and in trust for the people. Now, the other suggestion was that, again, it belongs to the people, but then it should vest in a commission, in a natural resource commission, which would use it on behalf and in trust for the people. Now, I do have problems with both of those suggestions, because in the first place, we are talking about the government, okay, and we're not talking about a particular office. So we wouldn't want to vest natural resources in the president, in the office of the president, for good reason. One, when you look at the management of natural resources, you notice that it is across various sectors. So we just discussed NMA and EP and Ministry of Lands. So it spans a single office. So it would be difficult to pinpoint natural resource vesting in just a single person, in the president. So it really would make sense for us to have it dispersed across the government rather than the president.
It's a standalone?
Well, not necessarily, but when it goes across the government, then it sort of captures the issue of collective responsibility. So each of these institutions have a stake, and if they do not perform as expected, then there could be consequences that follow. And that takes me to the second point. Now, you are aware that the president has immunity under the Constitution. So essentially, he could not be sued criminally or civilly whilst he holds office.
In a situation of breach.
Exactly. So if you create a trust, you're creating a relationship, and you are conferring rights on the beneficiaries to take the trustee to task if the trustee fails to act in the interest of the beneficiaries. And so if you vest natural resources in the president, who cannot be sued whilst he holds office, then you are essentially really killing the trust relationship. So unlike the president, the government does not have immunity. So specifically, we can bring action against EPA if we think EPA is not following the tenets of the trust relationship, if EPA is not doing the job that it's supposed to do. The same thing for NMA. But if you vest it in the president, then the president cannot be sued, and we will not be able to take steps against him for any breach of those trust relationships. So we would rather love to see, and particularly I would love to see, the committee adopting a clause that vests natural resources in the government as a whole rather than in the president, or even in a commission. Because again, as I mentioned to you, having a super commission that deals with all of these things is not proven as a very effective measure. So the government could be the best repository of that trusteeship relationship, not the commission or the president.
As a third option.
As a third option, indeed. So
Okay.
so that is something we have suggested that the committee looks at as a third option.
Well, looking deeper into the draft, especially in the area of section 2 and 3, which contains definition of renewable and non-renewable. This section, however, could either be omitted or set out as substantive provision and just final. Again, given the explanation, which is very much thorough on the aspect of land, when we talk of renewable and non-renewable as an element on the land regime, what are we simply referring to here?
Well, essentially what we mean here, and again, that is something we suggest the committee to take another look at. Because
renewable and non-renewable.
yes, they provide definitions of that, but we think there is no need for a definition of those because people know those, what these are. But essentially, they are natural resources that are renewable. That is, with time, they can come back. But there are others that are not renewable, that once you exhaust them, once you use them up, you're not going to get them back for a very, very long time. So let's take, for example, the fish in the sea. People go out and fish almost on a daily basis. Now, it's a natural resource. Well, then the fish have a cycle. They give birth, the small fish grow up and become big fish, and we go in again and we take them, and So the cycle is always there. The resource comes back again. But for certain other resources, and that again really points to the fact that we need to be very responsible in the way we manage and exploit the natural resources. Once you exploit them, they are gone for a very, very long time. So imagine if we dig up all the country and remove all the diamonds that we have. Now diamonds are not easily renewable. I am aware that it takes many years for the process that leads to to diamond to complete itself and for us to have diamonds. So we have to be very careful about those non-renewable natural resources. And it's important that the Constitution is paying attention to them. And what we would want to see would be very clear guidelines, general guidelines within the Constitution that stipulate responsible ways of managing those all of those resources, whether they are renewable or not renewable. So we want to see very clear stipulations within the Constitution that sets out how those are going to be managed and exploited.
Well, perhaps the argument over time that has been proffered is the fact that as a nation we are blessed with what the Minister of Fisheries, Captain Mamadou Aliou Patso, refers to as having a continental shelf. That is the land drifting into the sea. That depository is where you can experience the settlement of fish and they reproduce. That in itself is natural, and there is no way as a nation we can be short of having fish in the sea. So that aspect perhaps could be better explained by the fisheries department. But having said that, I think out of curiosity, I had wanted to congratulate you. Initially, I read in so many newspapers that you've won a land case in favor of landowners with a Chinese investment company. How did that come about?
Well, thank you so much for that. And again, you know the kind of work we do. We provide legal services and legal empowerment for communities that may not necessarily know what the law is or have any dealings with legal institutions. Now, the background to this case was that several years ago, the paramount chief of Nimiama entered into a deal with a Chinese company to sell huge tracts of land to the company. Now, these lands belong to families, and these families were not consulted, they were not part of any of the processes. And eventually, the company went in and took possession of over 1,400 acres of land that people had been farming on, and so meaning that at that time they were evicted from those lands and their livelihood was put at stake. Now we're aware that steps were taken to have that issue resolved amicably, but without any success. The landowners complained to various institutions, including the Ministry of Local Government. And I must say, the Ministry of Local Government did its own bit to try and get a resolution of the matter, but somehow there was a pullback by the local authorities from actually resolving the issue, to the point where the Ministry of Local Government requested a legal opinion from the Ministry of Justice about the situation, which the Ministry of Justice did provide. But then somehow those who were involved in the deal refused to acknowledge the opinion and the continued cries of the people for them to be given back their land. And they had sold the land for about $130 per acre, outright sale of the land to the Chinese company. The company was going to do a rubber plantation on the land. And so as a result of the lack of movement across any resolution, the people heard about what we were doing and they sought our help. And so we came in last year, and the first thing we did was to write to the different parties, including the Ministry of Local Government, to say that we want to have this issue resolved. But unfortunately, the local chiefs and those who were involved did not acknowledge our initial offer to have the issue resolved. And so we were left with no option but to go to court, because we think that the court can and does defend the rights of people. And I must say I'm very pleased with the way the judiciary distinguished itself in this particular case, because we went to court last February, and within a year we had gone through the processes and gotten judgment from the High Court. And essentially what you read was absolutely correct. The court gave back the land to the to the plaintiffs, who were the landowners and the many families they represent. And the court also said that the company should pay damages for the periods that they had evicted the people from the land and they could not use the land to get their livelihoods. And so the court gave them quite substantial damages and also issued an injunction against the company, the paramount chief, and all those who were involved in the particular process. I think for me, the critical thing is that it works. You know, you can access justice in these situations. And this is what we've been pushing for quite a while. Often our people in the rural areas do not have access to legal services. Those who are opinion leaders or traditional leaders go in and take advantage of that. So they go in and settle certain deals, certain agreements with corporations without, you know, batting an eye to the interest of these communities, which we think is wrong. And I'm thankful that government has acknowledged that by adopting the land policy, which now very clearly clarifies the position.
I was just about to ask the question,
Yes.
given the fact that in law, precedent is a critical element in determining future
Sure.
instances. How could this better serve as a lesson for any future dealing with duty bearers in any community that may want to enter into contracts, contractual agreement and land, be it on lease, purchase or whatever thing, that could possibly avoid shared confrontation as the one you've just settled?
I think, I mean, the lesson is very clear, that you cannot deal in land in the provinces without seeking the consent of those who own the land, the families. I think it's unreasonable for those who claim to know customary law, for those who claim to lead the people, to enter into transactions that are detrimental to the people. You don't want to be seen to be doing that at all. And this particular case really drives the point home, that there are institutions, there are people who can provide assistance to communities to ensure that those things that their leaders do that are not in their interest are resolved by the courts. And I think it's a very clear message that, you know, the court also has sent, that they are open for business, and that if people feel their rights are infringed, they should have confidence to come to the court. And we put ourselves out there to be willing to assist whichever communities or groups or families that are suffering from these kinds of situations, to ensure that we address that. And as I mentioned to you, the policy now clarifies that, and that policy is going to be translated into a number of laws. That land that is owned by a family is vested in the family. So you have to deal with the family if you want those lands. Land that is owned by the community is not vested in the paramount chief. It is vested in the chiefdom council, if it is a chiefdom land. And that is a point that we've been making strenuously over the years. Mm-hmm. That when you look at the Provinces Land Act, it tells you that land in the provinces is vested not in the paramount chief, but in the chiefdom council, which is a body corporate, which is an entity comprising of a number of persons. So it is not vested in the paramount chief, it is vested in the chiefdom council. And it is that council that can take the steps that could lead to whatever administration that is required of the land. So people need to understand that very clearly, that the land is not vested in the paramount chief. The paramount chief is a member of the chiefdom council, but he by himself unilaterally cannot enter into arrangements with companies. No, it has to be the chiefdom council as an entity that does that.
But the wordings seem to be misleading. The custodian of the land.
Well, when you look at the act, it is very clear. It doesn't say that the paramount chief is the custodian of the land. It says land in the provinces is vested in the chiefdom council. So the chiefdom council holds those lands on behalf of the communities concerned. So there is no mention of the paramount chief as being the custodian of the land under the Provinces Land Act. It says it's the chiefdom council. The paramount chief is essentially like the CEO of the chiefdom council. So you can imagine a company that has a CEO. Now the CEO does not own the company. The CEO is an officer of the company, but he is perhaps the primus, the prime officer of the company. And so whatever the CEO does has to be in tandem with what the company wants. The company has members and shareholders, okay? And so the CEO has to act in accordance with their wishes. That is why the act is very clear. It doesn't say it's the paramount chief. It says it's the chiefdom council. And the chiefdom council comprises a number of different persons who are there, principal persons of the chiefdom. The paramount chief happens to be the presiding officer of the chiefdom council, but he or she cannot unilaterally enter into these transactions without consulting and seeking consent from the others.
How much do you know, given the fact that you've taken your time off over time to ensuring that these acts, people seem to understand them better when they want to enter into any contractual agreement on land, that the duty bearers do understand these fundamental things that you seem to be explaining? Or could it be on a second thought, they are doing so on what perhaps I may refer to as survival instinct?
Raman, I agree with the fact that the aspect of awareness with respect to land use and rights is minimal. And part of what we do, our process is not about providing legal services to communities, it's about empowering them. So whenever we work with the community, at the end of the day, we want them to be so empowered that they're able to know what their rights are and to take steps by themselves to resolve those issues in the event those issues recur. But I say again, awareness, education is quite minimal, especially legal education, legal awareness of some of these things. And now that we have a new land policy, one of the critical things that needs to happen is that to ensure that people are aware of the provisions of the land policy. Because there are fantastic provisions in that land policy. There are groundbreaking, progressive provisions in the land policy that people need to understand. Because without knowledge, you're not able to defend your rights and your interests. Once people don't know, it becomes a problem. I just came back from the provinces, going to see some of our clients in those communities. And in one particular meeting, the first question I asked them was, who do you think own land in the provinces? And I had so many answers. They were quite interesting. And so I took my time to explain to them exactly who owns land and what the national land policy actually postulates. And you could see the dawn of awareness, like, ooh, I see, on the faces of these men and women. Because for the first time, someone was taking their time to explain to them exactly what their rights are and what their obligations and duties are. And so I think it is critical for people to understand exactly what these laws provide. Because without this, we're not able to empower them. Without this knowledge, they would not be able to come to the courts. Because they see the court as something mysterious, something for those who have gone to school. And so that is why you find that many people view courts suspiciously. They're like, no, this is not for us. We will just bear and just, they have this saying that I left my case God. I go bear. Basically, that's what people say, very fatalistic. And we don't want that to happen. We want people to be confident enough, people to know their rights, and to be able to take steps when those rights are violated, particularly when those rights are violated by either their traditional rulers or by companies coming in. You see, and we find so many examples of that across the country, where companies are going in and taking advantage of the lack of knowledge of communities. We spoke to a number of paramount chiefs, and they also have these points that people don't understand, and we don't have the help. And so these companies come in and take advantage. Mm-hmm. We have seen examples of companies taking land from communities, mm-hmm. all of their lands in many cases, mm-hmm. without a single document to show the transaction. Well, they are planting on those lands, thousands and thousands of acres of land, and they're not paying rent, and they're not doing what they're supposed to do. And these communities are without land, and they're not even receiving rent, and there is no document to show what the nature of the relationship is. It's so common across the country. And I think it's something that we need to work very quickly and seriously to address.
So do you see education, or better put, sensitization, as the winning ways in addressing some of these compelling challenges?
I think it's one of the critical ways. People need to be aware. People need to have the knowledge. Because I tell you, once people know, they have the confidence to stand up for their rights, to defend their rights in the proper way and at the proper time and in the proper forum. And so we should not underrate that. We should not undercut that. People need to be aware of their rights. People need to know what is in the law. Because as far as they're concerned, the law is in the books. We should get the law out of the books. We should make the law real to the people. We should be able to let them relate with the law when they go about their normal business. And so that is what we try to do, to actually bring the law to their scenario, to their situation. And if you don't do that, people will continue to fear the law, and you don't want that to happen. Like, the law is this mysterious thing that only those in wigs and gowns are able to deal with it, and it's not for us. Now, once people have that mentality, they will not be able to seek the protection of the law. And the reason why we're having constitutions, why we're having laws, is essentially to ensure that across the country, everyone enjoys equal protection of the law. But if you don't know what the law is, you are never going to benefit from the protection of the law.
I envisage a situation where better enlightenment could take precedence in all of these given communities, for people to understand what their rights are when it comes to land acquisition and what the necessary contractual agreement is. That we are not calling for a revolt, but I envisage a very gloomy situation, especially with some multinational corporations that are operating out there. But over time, what has been the case is the so-called educated people that are in the midst of these local natives that decide what this multinational corporation should do with the acquisition of land in, well, perhaps not in the interest of the local natives, but duping them, giving the impression as if everything is well. It started off initially by saying that in the drafts, it is suggested that the multinational corporations that intend to go into business with these people, they must be able to give basket fund.
Yeah, they must be able to contribute something.
Of what importance could that serve?
I mean, that would be very important, absolutely, because what it means that there would be resources to put back into the community once the company leaves. And if the company has degraded the community, the environment, then those monies could be put into restoring those communities, absolutely. And I take your point that we do have a number of instances where it is not the government that is pushing or supporting a particular company that really is riding roughshod over the people. It is actually someone who claims to be a son of the soil who perhaps has contracted that company from outside and comes in and says, these are my people and I want to do this and that for them. So you find within those communities local elites who are actually the cause of much of the woes of the people, not necessarily a government person or the government per se. And again, education would be critical because people must understand that now companies could come in, but they have to be responsible in their approaches, in the way they carry out their activities, because otherwise it becomes a problem for people. And I can tell you we have a lot of examples of local elites actually selling their communities out because they were promised either positions by these companies or some sort of monetary compensation, that if you deliver the deal, then you get this or that, which we think is wrong. You're not serving your community very well, and that is a problem.
Well, so Nkisa, quickly, we don't seem to be having much time. My expectation here was to have seen most of these government institutions that have the responsibility, whether an oversight responsibility or you are there to enforce the regulations, to do due diligence. Instead of, but before you given a nod for the operational activity of any company. For instance, you're talking of NME. If a claimant of land should come before you and say, we've done A, B, and Z, it is your responsibility to look critically from A to B whether there is conformity with these stipulated rules before ensuring that this company ought to operate. This is primarily what has been the challenge, especially in the suburban areas at Kamakwe. I'm pretty much aware as to what is going on there. I am not making this frequent example on the fact that I'm only pinpointing or rather trying to expose things that are happening there. But the challenges are enormous when it goes to Kamakwe between these landowners, legitimate landowners, and these multinational corporations. I think the box stop also with the enemy, the Ministry of Mines and Mineral Resources, and also the EPA when it comes to land degradation. They need to collaborate, as you emphasized initially.
I absolutely agree with you, and I think one of the key things that we're going to be pushing for is that we need to have a paradigm shift on how we approach large-scale investment in the country. I think we're going about it the wrong way. Take, for example, a company wants to mine. the company comes to Freetown, gets a mining license
Exactly.
from NMA, gets an EPA license, and then goes into the community and says, I have government approval,
Exactly.
so I'm going to take the land. I
That's
pay
a use
this
of a
amount
trump
money."
card.
So that is a problem, and I think we need to switch that around. And I think when you look at the draft report, the draft CRC report, they seem to be suggesting that we make that particular switch. So instead of coming in to get government license first, why don't you go to the communities, fulfill all righteousness with the communities, and then use that now as a basis to come and get the government licenses? So once communities are satisfied that, yes, we want this company, they would accompany you to come and get the license from government, because you would have fulfilled all the protocols that you need to do. But if you come and you get the government license and you go down and you simply flash it on their face that, hey, government has given me this land and I'm taking it, then I think it's a big problem. So we need to change the order of things when it comes to large-scale investment. And I think the draft report does make some very good suggestions with respect to how that is done.
Finally and quickly, what is this aspect about corporate social responsibility? Because that in many cases has been used as a facade where they will come, for want of word, they can do corporate social responsibility to lure the interests of the landowners so that they will get what they want at the end of the day.
I agree with you that that particular terminology has been abused over time by many companies, and perhaps, again, some of your colleagues in the media.
Mm-hmm.
Because what is corporate social responsibility is simple. Essentially, a company is a citizen, is a corporate citizen, because the company is a person.
Mm-hmm.
And just like any other citizen,
Mm-hmm.
you have responsibilities to the state. And so the company should also have responsibilities where it is doing business. And those things would be doing things that are not within your obligations, doing extra things, other things that are not within your obligations to get a license, to pay rent, doing other things. So, for example, you could say, well, we want to contribute to this particular community.
Construction
We
of
don't have
bridges.
schools. Could we, pay for teachers to come in and teach, or could we provide, certain amenities like bridges? So that is corporate social responsibility. But nowadays, it seems as if everything is now tagged as corporate social responsibility, which is not the case. That shouldn't be the case, because it's quite frankly different from contractual obligations that a company would have towards either the community or the government agencies.
Okay. On this note, without much ado, I want to thank you so much, Sonkita Conte, Director Namati. Once more, may I congratulate you for winning a very important case for the landowners.
Thank you so much.
Keep
and it's
the
a pleasure
fire burning,
being here.
and I hope, is it pro bono?
Absolutely. We don't ask our clients to pay.
Good.
Yes, we don't.
That is patriotism to the highest degree. Thank you so much for being my guest on this program, Familiarized with the Law. Looking forward to be discussing other pertinent issues that borders around the intricacies and complexity of the law. Thank you so much.
Thank you too.
Viewers, this is how I bring out the curtain in today's edition of the program. My guest in the studio, Namati Director Sonkita Conte. I have been the presenter of this program. My name is Abdul Rahman Kamara.